It is my pleasure to introduce Kansas Solicitor General Tony Powell.
Good afternoon. Thank you, Judge Smith, for those very laudatory comments. I really appreciate that. It's very kind. It's funny, I do remember our days over at Martin and Churchill for many, many years ago when you were fresh out of law school, out of Regent, and I remember all the energy that you had then, and you still have all that energy, which always amazes me. I'll be honest with you, I never really thought I'd be standing here, being as Solicitor General, addressing the crowd about some of the things that we're talking about today. I really thought I'd still be on the Kansas Court of Appeals. For those of you that don't know, I spent 20 years on the bench. I spent 10 years as a district court judge here in Sedgwick County, and then Governor Brownback appointed me to the Kansas Court of Appeals, and I did that for 10 years before I retired in 2022. What you also may not know is that before that, I spent 8 years in the Kansas legislature. In fact, I represented the 85th district that's now represented by Patrick Penn, but Steve Brunk, who's here today, he succeeded me in the 85th district, and then we had Chuck Weber and one other guy whose name I can't remember. I don't think I want to remember, but so I kind of have one of the unique privileges of actually now having served in all three branches of our state government. I served in the legislative branch, I spent 20 years in the judicial branch, and now I'm working in the executive branch. And I can tell you just from firsthand personal experience, they're all very different. They have different roles in our government, different approaches to the way they do their work. And so it's been interesting to bring those perspectives to this particular job. I will tell you that the best job I ever had was being a district court judge. I loved being a district judge. I loved getting to put my robe on, and I know we have a number of district judges here today, all friends, but I loved going into the courtroom and putting my robe on and getting to interact with lawyers and the public. The Court of Appeals, which much more of a cloistered environment. Now, of course, it had its own enjoyable aspects to that job. I enjoyed getting to tell district judges what to do. That was kind of fun. It's also, particularly when you would issue a published decision on a particular issue, you got to actually push the law in certain directions, and I found that to be very rewarding and a gratifying experience. I really enjoyed my colleagues on the Court of Appeals. We came from a lot of different perspectives. They didn't really quite know what to think about me when I first arrived on the scene because I'm this right-winger coming onto the Court of Appeals, and I think I made them nervous, but with my affable way, they grew to accept me, and I'd tell them what I think, and I think it worked really well. I really enjoyed my time on the court, and I will tell you that just the courts get a lot of hits, and many times it's deserved with some of the decisions, and I'm going to take a few shots at the judiciary probably today in some of my remarks, but I will tell you that to a person, they work very hard. They strive to do what the law requires. That was my experience. I think you should feel good, generally speaking, about our judiciary here. I think they try to do the right thing and do what the law requires most of the time. They don't always get it right, but I think they work hard, and I think you can feel good about that you've got people, because we need it. Our institutions are under assault every day, and we need good people who are willing to step up and serve in these jobs that many times can be thankless jobs, difficult jobs. And we need people who are smart and dedicated and principled to do them. And you're very fortunate that, particularly here in Sedgwick County, where we elect our judges, you've got judges that represent and share the values of this community. And I always felt that was really important for district judges. You want judges that are in step with the values of your community, because district judges in particular people don't always understand that in many decisions that they make, they have what is known as wide discretion. So it's just basically what they think is the right thing to do. So you want people in those jobs that share your values, that you can trust that day in and day out, when nobody's looking, they're going to make good, sound, wise decisions on the bench. And I can tell you from just firsthand personal experience that here in Sedgwick County, you've got really good judges. And that's not a small thing, because the Sedgwick County District Court bench is the largest in the state. They're up to, 30 judges plus a magistrate? So it's a big judicial district. They hear, well, when I was on the Court of Appeals, a quarter of all criminal cases, just criminal cases, came from Sedgwick County. So they're hearing a lot of cases every single day. They're working hard, and they really deserve to be praised for the work that they do. As I touched on just a minute ago, I didn't really expect to be in this job. As I mentioned, I retired in 2022. I didn't actually plan on doing that. That was actually not my plan. I really planned to probably serve to 70 or something like that. I enjoyed being on the Court of Appeals. I felt like I'd hit my stride on the court. But when I made my announcement that I was going to retire, it raised a number of eyebrows, both among my colleagues, because I'm not that old. And I announced my retirement doing a Republican administration, which, again, wasn't something that I really thought I would ever do. A Democratic administration, excuse me. I would have preferred to have a Republican governor appoint my replacement. But I announced my retirement because of my loyalty to my wife. And I feel like it's important for you to know that my wife's got some health issues. And she came to me in the fall of 2021 and said she's spent 20 years as a Christian school teacher, and she said she just couldn't do it anymore. And so that forced me to make a decision about, wanting to provide for my family and do meaningful work. And so fortunately, I had enough years in the judiciary where I could retire and take my pension and go do something else. But I think it's important to share that with you, because life's about keeping your promises.
Amen. Amen.
I apologize, but I just think there's too many people that don't keep their promises. And I wanted to keep my promise to my wife. And I feel very fortunate that I got to spend 20 years on the bench. I loved every day of being a judge. But I'm really thankful that after I retired and after General Kobach got elected, I got a phone call not long after the election from General Kobach, who asked me to come work for him as his Solicitor General. And I never thought that would happen. But it's a great privilege to work for him. I can tell you, I didn't really know General Kobach that well. I had met him on a few occasions, but I didn't know him. But I've gotten to know him in this job, and he's very committed. He's committed to the principles of limited government, of the Constitution. He's willing to take on some tough fights. He wants to lead a lot of those tough fights. He's really bright. In fact, he's one of the most gifted oral lawyers in oral argument that I've seen. I got a chance to watch him in action in one of our election cases that I'm going to talk about in a few minutes. But he's really good. And so, we've had attorneys general over the years of varying legal skills, some good, some not so good. But I can tell you just from firsthand experience that Attorney General Kobach is an excellent lawyer. He knows the law. He's got a sharp mind. And, I got to work overtime to keep up with him. So it's a great privilege to work for him. And I know he'd say that he's working hard every day to fight for Kansas. People often ask me when I say that I'm Solicitor General, they always kind of give me that look, well, what does Solicitor General mean? And, it's a good question. I actually, Solicitor General is a great title. I mean, I think it's one of the best titles you could ever have. I mean, it's right up there with, Attorney General or Judge. I love having the title of Solicitor General. It kind of makes you feel important, probably more important than I really am. But in fact, one of the greatest things about the job, and I've never had one of these before, but I got a badge. And I'm thinking, how cool is that? You get a badge. So I guess that makes me a lawman or something, right? So that's pretty exciting. I never really thought of myself as that, but I guess with a badge that makes it official. But what solicitors general typically do in most attorney general offices around the country is we're the chief appellate lawyers for the state. And that's my principal role for Attorney General Kobach. I do a few other things. Our solicitor's office this year started doing, we write the Attorney General opinions for our office. And in case you don't know what those are, the Attorney General is frequently asked to give legal opinions on disputed legal questions from various government agencies, local governments, prosecutors, legislators. And we will opine not on every one that we're asked to do, but certainly on the ones that we think are important enough that an answer is really needed. And those responsibilities were transferred to my office at the beginning of my term in office, our term back in January, about a year ago. And I think the general thought that given my experience writing opinions on the Court of Appeals, I was kind of the ideal person to do that. And so we've undertaken that responsibility. Attorney General opinions, of course, aren't like court decisions where they're binding, but they do provide important persuasive guidance to various government entities and individuals who seek our advice on subjects. And so that's one of the other things that we do in our office. Our office is a very busy office. The Attorney General is the top lawyer for the state. So at the end of the day, our responsibility is to represent the state in all appellate litigation. And currently, we have about 150 cases that are up on appeal. The vast majority of them are criminal appeals. Now, our states are a little bit different on criminal appeals and how that works. Even though we're technically the chief law enforcement officer of the state, we don't handle every single criminal appeal. The bulk of the prosecution that goes on in this state is done by your local county and district attorneys. And here in Sedgwick County, for example, Mark Bennett, who's an excellent prosecutor, he's got an excellent staff of appellate lawyers, and they handle their own appeals, though we do review their opinions. So we work hand in hand with county and district attorneys all over the state in reviewing briefs and reviewing the law. Our job, as I see it, is to make sure that every brief that's submitted to the appellate courts is professionally done, well-reasoned, and that we bring a consistent message to the appellate courts with regard to the state's position on some of the disputed legal matters that come to the appellate courts. And so that's an important role that I do. There probably a day doesn't go by where I'm not reviewing a brief. And I think I really can bring my years of experience in the Court of Appeals to help the lawyers that write briefs craft their briefs that's going to be effective to the court. Now, a few of the cases that I've set aside today are some of the hot button cases, but I don't want you to kind of leave here thinking that this is where all our attention is. These cases get a lot more attention, but it's really the bread and butter work of our office, handling criminal appeals, representing agencies on appeal. That's the bulk of the work that we do. We do that. I think our office does an excellent job. We've got excellent lawyers. I was very fortunate, typically whenever you have a change in administrations, a change in attorneys general, you usually see an exodus of lawyers from the office. And I'm very proud to say that only one solicitor left. When they heard that I was coming, they all decided to stay. And I really took that as a great compliment that they decided to stay. I like to think that's, the respect that they have for me. And that was very gratifying. In fact, I was privileged to bring one of my former law clerks, Ryan Ott, who worked for me here in Wichita many years as a law clerk when I was on the Court of Appeals. He's come to work for me in the solicitor's office and is doing a great job. In fact, he just won a case today in the Court of Appeals, so I congratulated him this morning. But we're fighting fronts on many different battles. Of course, as I've said, we have a lot of cases in the Kansas appellate courts, but we've got cases in federal courts, both here in the 10th Circuit, which is where Kansas is part of maybe I'll just give a short explanation. Our Kansas courts are organized similar to the federal courts. You have our district courts, which, like here in Sedgwick County, we have the Sedgwick County District Court, then you have the Kansas Court of Appeals, and then you have the Kansas Supreme Court. Well, federally, of course, you've got the Federal District Court of Kansas, and then you've got the 10th Circuit Court of Appeals, and of course there are several states, Oklahoma, Kansas, Colorado, Wyoming, Utah, New Mexico are all in the 10th Circuit, so any federal appeal will go to the 10th Circuit, and then of course ultimately up to the United States Supreme Court. And so we have cases in every single level of the court system, plus we've undertaken to write amicus briefs and led the fight on a number of other cases, which I'm going to talk about. But we're fighting issues on a wide variety of issues, whether it's economics. We're part of a group of states that we filed what is known as a petition for review in the D.C. Circuit Court of Appeals in Washington, D.C., challenging the Environmental Protection Agency's approval of a California rule. And you guys ought to pay attention to this one, because California has instituted an emissions requirement that will have the effect of putting internal combustion engine semi-trailer trucks out of business in just a few years. So you can imagine the impact that could have on the cost of shipping goods when you think of the volume of shipping that goes through California. Los Angeles and Long Beach is probably the biggest port in the United States. And so you think of all the goods that go through California, if all transport has to now be through an electric-powered semi-trailer truck, which that technology is really kind of in its infancy. I know Tesla, I think, has come out with a semi, but I think they're still developing that. Well, we're obviously very concerned about what that may mean to all of us in terms of the costs of transporting goods. So those are the kind of fights that we're fighting, and it's important that those fights be fought. I'm going to talk about a lot of the hot button stuff, but it's stuff like that. We're fighting, and Judge Journey will appreciate this, we've joined briefs in the 9th Circuit in defense of gun owners. California is basically hell-bent on violating the Second Amendment anytime and every time they can. And there's two cases that are almost side by side. One involves magazine limits, and the other, I think, is bump stocks. But we've joined in those briefs. We're fighting Second Amendment fights all over the country with our fellow Republican AGs. We're fighting a lot of good fights, a lot of important fights, and we're raising important arguments that need to be raised, both whether it's gun rights or your economic freedom, whether it's parental rights. We've joined on to briefs protecting parents from, there are school districts that think it's okay to keep it a secret from you that their child wants to transition to a different gender identity. And we think that's an assault on parental rights. It's one of the most fundamental assaults on parental rights. Parents have the Constitution says you have a constitutional right to control the care and upbringing of your child. And we find it deeply offensive that school districts would want to interfere with that right on some of the most basic, fundamental questions that they're facing. So we've joined briefs on that. That personally is very important to me. And we signed on to a number of briefs. Religious freedom, where there are many government entities who want to pick on, I forget the state now, but there's a case that we've signed an amicus brief on where they've enacted basically it's a school choice program, but they claim that their state constitution doesn't allow that money to go to any religious schools. Well, we think that violates the First Amendment, and there's clear Supreme Court precedent on very similar issues. So we're joining other states fighting that fight, and that, again, that's an important fight. And I think we're going to win those fights. And so every day, those are some of the things that we're up to. Let's see if there was another case here on my list. Oh yeah, there's another case, and this is the other thing I really appreciate about Attorney General Kobach is that he's willing to stand up for the little guy. It's not just about, powerful interests in our country. They get good representation, but they're just regular people. And this Attorney General doesn't shy away from doing its right, even though it might ruffle some feathers. And a case that we've got in Johnson County, there are some homeowners who, if you've ever been up to that section, it's kind of Highway 7 and 35. There's those big, like Amazon warehouses, kind of near Olathe and Edgerton, in that part of Johnson County. If you've ever driven by there, you can see the way that's developing. Well, the city of Edgerton wants to sort of take advantage of how that area is developing, and they annexed some broad swaths of rural Johnson County in order to expand their ability to have warehouses be built. But the problem is that their annexation was, at least in our view, illegal. And they completely ignored the concerns of property owners in that area about how it would impact their property and the safety of you're talking small county roads having big trucks on them. And, no one was really willing to stand up for them. They didn't have standing because their particular property wasn't annexed. They didn't have standing to go into court to challenge the city of Edgerton's annexation, even though it was illegal. And the city officials kind of laughed at them, really. I mean, they just basically said, well, go fish. We don't really care what you think, which is kind of amazing. So when I came into office, some of the staff were telling me, well, we were going to file this amicus brief in this case, but we don't really see what good it's going to do. And I'm like, well, why don't we sue? I mean, the Attorney General, here's another thing, one of the important powers that the Attorney General has. We have a right to bring lawsuits on behalf of the people of the state to ensure that other government entities are following the law. It's called a relator action. And I said, we should file a relator action, an enforcement action against the city of Edgerton, and have a court decide whether this annexation is really legal. But we think it's not, and we think a court ought to hear those arguments. And so we filed suit not long after I came on board, and we're litigating that currently in the Johnson County District Court. So we're not getting any pats on the back. I'm sure the developers are very unhappy with us, and I'm sure there's other economic development interests that are unhappy with us, and I get that. But our position is simply the city is required to follow the law. And if they don't follow the law, they're going to answer to us. And so I think that's important, and we'll see what happens with that case. But that's, again, one of the important things, and one of the importance of the Office of Attorney General, because we can do things like that. We can defend the defenseless, the people who don't have the ability to defend themselves. We can go into court to vindicate their rights when that is needed. And I think that's good. I'm going to spend kind of the remaining time I have and talk about a few of the kind of the hot button cases that you've heard about in the news. Okay, that's a disclaimer. That's a bunch of legal talk saying none of this I'm telling you today is legal advice, so don't rely on it. Just one guy up here talking at you. You, of course, have heard in the news about the Colorado ballot case involving former President Trump. We filed an amicus brief in defense of President Trump in the Supreme Court. We filed it just on our own. We wanted to make some arguments that some of our sister states weren't making. But I wanted to show this to you because, before I came into this job, I had not filed a brief in the United States Supreme Court before. And so that was pretty exciting. But the one thing that might interest you, all our court systems have gone electronic. You can file electronically, and it's really been a great revolution. I think it allows the court system to serve people better, but it's really bad when it crashes. And as you may have seen in the news, of course, the Kansas court system's computer system crashed and is only now kind of getting back up and running. Now, they haven't really shared about how that happened. I suspect somebody clicked on the wrong link. Judge Journey, I doubt that it was a hack. It's certainly possible, but that's often actually how, outside entities get into computer systems. It's usually somebody clicking the wrong link, and then boom, you're screwed. Well, the Supreme Court, now, when I first heard about this, I'm like, the Supreme Court is in the Stone Ages. I mean, they're making us file paper briefs still. But you know what? The Supreme Court never can get hacked. And I'm kind of thinking, maybe they're geniuses after all. So anyway, to file a brief in the Supreme Court, you can't just, electronically file your brief, and it's really easy. With the Supreme Court, to file a brief, you've got to, have it nicely printed. It's got to be printed fancy, and it's got to be in paper, and you got to give them 40 copies. And so there's a bunch of printers out there that's all they do is they file briefs in the Supreme Court, they format your briefs and properly give all the right notices and file it properly. And so none of you have ever seen a Supreme Court brief, this is what they look like. This color is because it's an amicus brief. What amicus means is you're just filing a brief as a friend of the court. We're not a party to the case, but we felt like we had some views that we thought the court should hear. And this is the brief that we filed, and we just did this a couple weeks ago. But in this case, as you might know, there were voters or electors in Colorado. Interestingly enough, they apparently were Republican electors, but they sued under the Colorado Election Code and under Section 3 of Section 10 of the Article 1 of the Constitution, the 14th Amendment, Section 3, to have President Trump disqualified because he engaged in an insurrection. That in and of itself, I think, is a very unusual tact because typically state election laws, the qualifications that, our state statute lists the qualifications to be on the ballot. It's typically things like, are you old enough? Are you a resident? Have you filed the sufficient number of, do you have the sufficient number of signatures? Those are the typical kind of fights that a Secretary of State would decide. Well, these plaintiffs decided to go into court and try to have President Trump thrown off the ballot on the basis of the insurrection clause of the 14th Amendment. And I think amazingly, and I've read the decision of the Colorado Supreme Court. The Colorado Supreme Court, I think, did some pretty amazing things. One, they said, contrary to a lot of precedent out there that says you have to have, under that section of the 14th Amendment, Congress has to pass enacting legislation, actually define well for the purposes of this amendment, what is insurrection, how would you bar someone from the ballot. They're actually over 150 years ago, right after the Civil War, they had a statute in place, and that's how people, in fact, were barred. But it took a congressional act to do that. Here, they're just flat out, trying to use that, graft that provision of the federal Constitution onto a state statute to declare President Trump, not able to be on the primary ballot. So that's kind of an amazing thing they did. It was a 4-3 vote, which makes me feel good that there were, 3 Democratic justices of the Colorado Supreme Court who said, no, this isn't right. The other thing that the court said is that President Trump engaged in an insurrection, but in front of the district court in Colorado, they never had a trial in the true sense of the word where President Trump was allowed to present evidence or examine or cross-examine or challenge the evidence. They just brought in wholesale the record from the January 6th committee. Well, you've seen the news of what of a sham that was. I mean, that's like a kangaroo. I mean, there's no due process afforded to President Trump in the January 6th committee. It was hand-picked, cherry-picked, information that they put into the record to try to paint a picture of what happened on January 6th that really isn't a true, full picture. And perhaps even more amazingly, even though in the record they couldn't point to a single thing that Trump actually said that incited a riot or incited what happened at January 6th, they said, oh, but because he created this climate of fear. And they brought in a professor from Chapman University. I've never heard of Chapman University. And he said, well, he was speaking in code. And that code meant that all these people knew what he really meant, which means they were supposed to storm the Capitol or something like that. I have to say, I just found it amazing that justices of a state Supreme Court would swallow that kind of a record and take the kind of leap that they did to bar the leading Republican candidate for president from the ballot. That, to me, is absolutely frightening. And I have to say, frankly, it undermines confidence in the judiciary when courts do stuff like that, because it's just, it's very troubling.
And the Democrats have since deleted a lot of the stuff they had from that.
Well, yes, the January 6th committee, they've deleted, yes, a lot of the exculpatory evidence that they have, they've gotten rid of it. So a lot of it we won't ever get to see. Fortunately, now that the House Republicans are in control of the House, they're preserving a lot of that. But so that's the situation where you've got a 4-3 vote, and I'm very grateful for the dissenters. Their dissents, I think, were great. They were saying, one, the California election code, you can't use that process to bar someone under the 14th Amendment. That's really reserved for either the federal courts or to Congress. They also said, according to the evidence, Donald Trump wasn't given due process. He has a right to confront his accusers. He has the right to challenge the evidence that they present. He has the right to present his own evidence in mitigation, and he wasn't afforded any of those rights. That's wrong. Now, we didn't make those arguments to the United States Supreme Court because, in my mind, the due process argument is not ultimately a winning argument, because the other side can always say, okay, we'll give you your due process and then we're going to hang you. And I just, I don't agree with that approach. But here's what the 14th Amendment states. No person shall be a senator or representative in Congress or an elector for president and vice president, or hold any office, civil or military, under the United States, or under any state who, having previously taken an oath, either as a member of Congress or as an officer of the United States or as a member of the state legislature or executive or judicial officer of any state to support the Constitution of the United States and having shall engaged in an insurrection or rebellion against the same. Okay, there's a basic rule of constitutional and statutory interpretation that when you create a list of something, and that list excludes something that's meant because you meant to exclude that particular item. Well, you don't see president on that list, do you? It doesn't exist. And so our argument to the court was, well, one, there's another principle of the law that says whenever any provision of law is seeking to be punitive, they're going to punish you in some way with this statute, it's to be strictly construed against the government. And our position and the argument we made to the Supreme Court was this section, even if you were to assume that it's self-executing, which I think is a highly debatable point, and some of our other colleagues, AG colleagues, make that point in their brief. But even if you assume that it's self-executing, when you strictly interpret this language, president does not appear on that list. It doesn't include the presidency. And I think, now this is just me spitballing, just kind of thinking of the time in which they passed this. You know, this was passed right after the Civil War. What is it that they were really trying to accomplish with this? To me, it just speaks to you when you just sit down and read it. What they didn't want, you're thinking all these southern states that are in midst of Reconstruction, they didn't want people who had previously held office, you know, as a congressman or a senator or in the state legislature or state who had taken an oath to follow the Constitution and then joined the Confederacy to fight. You notice that clause doesn't include, if you were just some soldier in the Confederacy and you had never held public office, this clause didn't bar you from serving in office. Yet that person, quote unquote, engaged in an election. It was limited to people who took an oath to uphold the Constitution, had some office of trust. And I think what the Congress was saying was, if you took an oath to support the Constitution and you violated that oath, you don't get to go ahead and then serve in public office again. And that, to me, makes a lot of sense. I think that's really what this is limited to, and why the presidency wasn't included. They weren't worried about that because you had to get the votes in northern states to get elected president. I think they were thinking about, you know, we don't want southern states who have been reconstructed, sending representatives to Congress and to the Senate and to electing governors and state legislators who, you know, having been in that office before, violated their oath and then coming back and trying to serve again. I think they're saying, now you've disqualified yourself. I really think that's what this is meant to design against, not against what President Trump is accused of doing. So the other argument we made is that President Trump, there's nothing that he said that could be construed as insurrection when you look at the law with regard to threat or inciting a riot. None of his comments would fall under that, and so he didn't commit insurrection. And we thought that those were important arguments that needed to be made to the court. It's on a fast track. They've set the matter for oral argument on February 5th, so that's just a little over a week away. And I think the court is going to move very fast, and I expect that President Trump will win that case. I think there are many good arguments as to why the Colorado Supreme Court got it wrong. We've raised, I think, are a couple of good ones that others weren't talking about, but we thought it was a very important issue to bring to the court. We think it's really, you want to talk about democracy, I think this case is like an assault on democracy. Yes. The people have the right to decide for the office of president who they want to support. Not unelected judges in robes, not some bureaucrat, not a Secretary of State. I think the people should get to make that choice. And I think, I'm hopeful that that's going to be vindicated by the Supreme Court. The other thing I wanted to point out, a number of secretaries of state actually agreed with our position that this isn't really a matter for the Secretary of State to decide. and he joined with a number of secretaries of state and told the court, as secretaries of state, our job is to enforce the statutes with regard to ballot qualifications. But this question of the 14th Amendment, where somebody engaged in an insurrection, is a far bigger question that deals with the morality and the principles of a particular candidate, is not suited for the Secretary of State to decide. And so I think there have been a lot of good arguments made to the court, and we'll see what happens. Here's the other case that is in the news. It's in the news today. Of course, you've heard about what's going on at the Texas border. A lot of controversy. Now, there's really two cases, and we were a lead in, I think 15 states joined us in a brief that we wrote in defense of Texas. But there's basically two cases that Texas is fighting. The one that you're hearing about the news right now is a fight over barbed wire that they put up along the bank of the Rio Grande to try to keep the flood of illegal immigrants from coming across. What is not really being explained, and there's a lot of hyperbole going on, a lot of hysteria in the media. What happened was that the state of Texas sued to stop the Border Patrol from cutting down the barbed wire fence. And the Federal Appeals Court, the Fifth Circuit, issued an order barring the Border Patrol from cutting down the barbed wire fence. And they made an exception for, well, if there's somebody in the river that's drowning, and to rescue that person, you got to cut the fence to go rescue them. Well, okay. And so it was the Biden administration that then went to the Supreme Court to have that order overturned. And that was the order that the Supreme Court overturned. So this idea, and I'm seeing, news reports, Democratic congressmen are calling for the president to nationalize the Texas National Guard because they're defying the order of the Supreme Court. That's not true. Texas isn't under any order of the Supreme Court. It's the Border Patrol that was under an order of the appellate courts not to cut down the wire fence. There's no order that says that the Texas authorities can't go back and rebuild that wire fence if they want to. That's not a violation of the law. That's not a violation of a court order. So all this talk that you're hearing in the news about that is just simply wrong. The brief that we wrote is a similar case where it has to do with the floating barriers that Texas put in the Rio Grande to, again, try to stop this flow. And in that case, the Biden administration sued to try to stop Texas from doing that. And to me, this case, both these cases, show how our country is absolutely upside down when it comes to enforcing the law. I mean, President Biden took an oath to defend the Constitution. Well, what does that mean? It means that some of the basic things as the executive he's required to do, defend our borders, protect our people. Well, instead of doing that, enforce our laws. He's not doing any of that. He's literally refusing to enforce any aspect of our immigration statutes. I mean, President Trump proved you don't have to have an immediate change in our immigration law to stop this flow. You can do it through executive action because he has the tools to do it. President Biden is simply not doing that. And I think it's undeniable that we have an invasion going on. They're talking about, 7 million maybe have come in? We have no idea what that number is. I suspect it's even more. But think of the impact it's having. I'm sure the fact that you can't get affordable housing anymore has part to do with that. Our schools are overflowing. Medical services are being overwhelmed. When you have this invasion of people coming in, they're people, they need to eat, they need medical care, their kids want to go to school. All those things are being pressed hard. And so I don't think it's hyperbole to say that it's an invasion. Well, in the midst of this fight, Texas The Biden administration sued Texas for its placement of barriers. The Biden administration sought a temporary injunction to have that barrier taken down. The federal judge, I think, unfortunately, granted that order. Now, the arguments they were making to the court were really dealing with like federal supremacy, navigable waters. Is this a navigable water? And doesn't the federal government have primary authority to control the border? All the arguments were kind of circled around that. And, I will acknowledge that in the normal case, the federal government's got the stronger argument. But where I really feel like the courts are falling down in this area is they're overlooking a basic problem. What do you do when the executive branch is not acting in good faith any longer? What do you do when the executive branch is simply refusing to follow the law, refusing to force it? To me, that changes the whole outlook of what this case means, and that's the argument that we brought to the court. And I was really gratified to see that the Texas governor is invoking, in its Article 1, Section 10, Clause 3 of the Constitution. Now, I guess I need to go back and read some more of the Constitution because I guess I'm still learning, because I didn't even know this was in here until I started doing some research in this case. And I suspect that most of you aren't really familiar with this clause either. But here's what it says. It says, no state shall, without consent of Congress, engage in war unless actually invaded or in such imminent danger as will not admit of delay. And to me, again, it's a common sense provision that says, okay, think of when this was enacted. We've got this large country. It could take you weeks to get to the Texas border if you're in Washington, D.C. You've got General McClellan, whoever it is, sitting in D.C., and they've got problems on the Texas border. It could take them weeks to get out there to defend the border. Well, this provision says, well, a state doesn't have to sit around and let an invasion happen to them. They can act in self-defense. They can act to defend themselves, to protect their people. That was the argument that we made to the Fifth Circuit in our brief, and we got, like I say, 15 states to join us in that argument, and I think that's a very important argument. I appreciate the fact it's a novel one. I appreciate the fact that you're kind of pushing the boundaries, but we're in a situation where the boundaries are being pushed. We've never been in a situation like this where you just, again, I'll say it again, you have wholesale disregard by the executive branch of its obligations to defend our border, protect our people, enforce the law. They've literally abdicated that. And I think Texas has no choice, as any responsible government would do, to try to defend its people. And that has the effect of, helping all of us. And I think that's why you're seeing so many states, Republican governors, are coming to Texas's defense. Unfortunately, we don't have a Republican governor in this state, but we do have a Republican AG, and we, are one of those leading that fight to help Texas and help them help themselves. And so it'll be interesting to see what happens with that case. A panel of the Fifth Circuit ruled against Texas, but the full Fifth Circuit is going to rehear that case. And I'm hoping that they really will pay attention to the constitutional argument. I see I'm rapidly running out of time. I've talked way too long on a few of these big cases, but I thought they would be of interest to you. But these are some of the fights. I've got a bunch of other cases we're fighting. Just as quick as I can, about the transgender issue. We're litigating a case in the Shawnee County District Court. The legislature passed last year a bill called Senate Bill 180. And what it did was basically define, wherever it appears in state law, what sex means. Sex means biological, male or female at birth. And it says that any record of vital statistics that records in the data set particular individuals have to record them as their biological sex. And we issued an Attorney General opinion to that effect because the governor was making statements that they weren't going to follow this law. They believed that You know, they were already following the law, which of course was baloney, because here's what was going on for the past several years. The state allows you to go in and change your driver's license to reflect your gender identity, even though on the front of the license it says sex. They were also, and this was a result of litigation that I quite frankly don't understand why our predecessor didn't get involved in this case, but a number of transgender individuals in 2018 sued the Department of Health and Environment for the right to change birth certificates. And the governor entered into a consent decree, and a consent decree is really nothing more than a contract, but it has the sort of the blessing of the court, which technically it makes it an order. And they're allowing people to change their birth certificates to reflect their gender identity. So they're undermining, I think, the basic value and the whole reason why you have these documents. Well, we said we think all that violates Senate Bill 180, and the thank you. The Kelly administration said, no, we're not. So we did two things. One, with regard to the birth certificate case, because there was a federal case and they basically were hiding behind this consent decree, we went into court and said, Judge, the landscape has changed. Senate Bill 180 makes this order unlawful because the law now specifically says that the Department of Health and Environment has to have a birth certificate that reflects your biological sex at birth, and that the data set in which that contains must say that as well, and it doesn't allow anyone to change their birth certificate to reflect whatever they think their gender identity is. And Judge Crabtree, who's, to his credit, he's a Democrat appointee to the federal bench, agreed with us. And they never appealed. Surprisingly, they never appealed. So we put a stop to changing of birth certificates in Kansas. Well, the other thing we did is we filed a lawsuit against the Department of Revenue. As you know, the Department of Revenue is the state agency that administers driver's licenses. And we basically said the same thing. The law doesn't allow for that. Now, there's a bit of a twist in the law because there were changes made to comport with federal law where they use the word gender. And so, but our argument was, in this context, gender and sex are the same thing. And our argument is that your driver's license has to reflect your biological sex at birth, and the record of the department in their records has to also reflect that. We filed suit, it was in July. We got an immediate temporary restraining order from Judge Watson that basically stopped any further changes to driver's licenses. So everything's been frozen in place. We had our trial on the temporary injunction just a couple of weeks ago, and we're awaiting that decision. But I feel good about our position. I think our position clearly comports with what the legislature's will is. And we think it's beyond the power of the Department of Revenue to try to go its own way. Complicating this case, of course, is that the ACLU intervened in the case. A number of transgender individuals wanted to claim that it was going to violate this notion of informational privacy. Now, informational privacy has never been a right that's specifically been recognized as a constitutional right. There have been some instances in cases where, you know, like, for example, your Social Security number. If the government has your Social Security number, like the voter rolls, for example, it can violate your rights to expectation of privacy to not have the Secretary of State spread your Social Security number to anybody who asks for it. That's kind of the context in which informational privacy is typically thought of, where you have an expectation of privacy and the government doesn't have any really good reason for sharing that information. But there's never been a federal constitutional right to privacy. And what the transgender individuals are trying to say is that their transgender status somehow is this privacy right that they're entitled to have. Well, quite frankly, that's just not so. Just my personal experience is whenever I've observed a transgender individual, you can usually tell they're transgender. I don't think they're, I mean, respectfully, I just don't think they're keeping it a secret from anybody. And we, of course, they were faced with the awkward situation that they've been claiming throughout the lawsuit that they're subject to violence, and which I personally, I found those arguments offensive simply because, knowing Kansans as I do, I don't know anyone who hates a transgender person. Do you? I mean, we don't hate transgenders. I don't know of anyone who does. We may disagree with their lifestyle. We may wish they would choose differently. But no, I don't know of anyone who hates a transgender person and wants to commit violence against them. That was they were making these arguments, yet they didn't put on any evidence to support that claim. The most that they presented in evidence was, well, it makes me uncomfortable to have to share what my biological sex is to someone. That was the most that they had. They had no evidence to support any kind of threats of violence against them. And so I'm hopeful that we're going to get a favorable decision from the judge in that particular case. And I'm hoping that we're going to, it's been a couple weeks, so hopefully here in the next few weeks, we'll get a positive result of that case as well. We filed a couple of cases in defense of one case in Oklahoma. What's interesting about that case, it's their birth certificate statute. Judge Brooms, who's a federal judge here in Wichita, was asked to sit on this case. They've been kind of burdened. You might remember from a year or two ago, the Supreme Court made this big decision about tribal rights. And so they've kind of jumbled up. It's caused the federal courts to have to start hearing a bunch of tribal cases, and their federal judges have gotten really busy. So they've asked some of the Kansas federal judges to come in and help them out. And Judge Brooms, who's here in Wichita, he was the judge that was assigned to this birth certificate case in Oklahoma and did an excellent ruling that basically said you have no, informational privacy right. In fact, you have no right. What you're really trying to do is tell the government how to create its records is really what you're doing, and you don't have a right to do that. And so we led a 20-state effort, amicus brief in the 10th Circuit defending Oklahoma. We filed a similar brief in the 6th Circuit in defense of Tennessee. And I like our chances in all those cases. We've got 3 abortion cases currently in the appellate courts. I argued 2 of them back in March. I really thought we'd have a decision by now. I'm a little surprised. I like to think that maybe I got them to think about what they're doing. I don't know. I kind of got roughed up pretty badly. But one has to do with the regulations of abortion clinics. The legislature passed a number of years ago a requirement that they have the same clinical standards as an ambulatory surgical care center. So it increases the health standards that they have to have. They, of course, are opposing those and sued to stop those. Then the other one has to do with we banned what are called dismemberment abortions. And it is as bad as you think it is. I mean, it's where they chop up the baby and pull the pieces out. And what was amazing to me is one of the justices on the Supreme Court, when I was arguing the case, was trying to say, well, counselor, isn't that just really overwrought because they can't feel any pain? And my response, well, Justice, I don't think that's true, 1, but 2, we wouldn't do that to a death row inmate. Can you imagine the state anesthetizing a death row inmate and then chopping them to pieces? What do you think those justices, same justices on the Supreme Court, would think about that argument, that method of death? They wouldn't tolerate it for a second, but apparently if you do it to babies, that's okay. So we feel very strongly that that statute's constitutional, but I'm not very confident of what the result is. The latest one, the abortion industry sued to invalidate the Women's Right to Know Act. And this act has been in existence for a long time. I mean, this was passed, I was in the legislature when the Women's Right to Know Act was passed in the late 90s. And it was bipartisan support. Governor Graves, who was pro-choice, signed it into law. I think there was like 1 vote against it. So it had the support of the pro-life community and the pro-choice because it was seen as we're giving women information about the true consequences of their choice and about gestational development. And It also imposed a 24-hour waiting period, which we think is minimal. The most recent change that was done is, of course, there's the abortion pill that's come into widespread use, but there's also a pill that can reverse that. And the legislature added an amendment to the Women's Right to Know Act, and I think this is really what triggered the lawsuit, that says you have to tell women that there's a pill they can take. If they take it right away, they can reverse their abortion. And I think that provision of the law is what they're really after. And unfortunately, the district judge in Johnson County gave the abortion industry a complete temporary injunction against the entire law, which respectfully, I think, violates the standards for a temporary injunction. One of the things you need to show to get a temporary injunction that you have immediate irreparable harm. Well, I don't know how the abortion industry can say they suffer from immediate irreparable harm from the Women's Right to Know Act when it's been in effect and they followed it for 25 years. So that case is now on appeal, and that's one of the fights that we're fighting. We've got a few election cases. I'm going way over. Do I need to stop? Okay. All right. I won't take much longer. We've got several election cases. There's a case that was just argued in the 10th Circuit last week. We have a law that says you can't send voters pre-filled out advance ballot applications. A federal judge here in Kansas, kind of amazingly, I still don't understand the reason that somehow that violates an organization's First Amendment rights. You have a First Amendment right to fill out a form for somebody and send it to them. That's apparently a First Amendment right according to the federal court. So we've got that case that we just argued in the 10th Circuit. We'll see what happens there. So we're fighting on that front. We've got a case where the legislature passed a law that says you can't impersonate an election official. They've challenged that. That's going to be argued in the Supreme Court at the end of February. We've got another statute that limits the number of ballots you can harvest. Basically, you can collect 10 ballots, and it's all designed to prevent voter fraud. We also have a signature matching requirement, which, in our view, is some basic, ballot integrity measures. Unfortunately, my former colleagues on the Court of Appeals, Judge Hill, who I love dearly, but I don't know what he was thinking in this case, he said that all our election statutes should be subject to strict scrutiny and struck down all these requirements. And I think it ignores one of the basic things about the right to vote. The right to vote is different than the other rights you think of. Your right to free speech, your right to conscience. Yes, go ahead.
I've been pre-registering people, and that pre-registering forms, that especially if they're, it's real quick, but it's important. We've been telling them that if they'll fill it out for us,
Go ahead.
Fill it out. It's because if they're disabled, they get it sent to them the rest of their life, already filled out, so they don't have to stand in line. Is that the form that you have in question?
Yes, I mean, it's.
So we need to wait for that.
No, I don't think you do. I mean, that's been the in-state law, but no, I don't think you have to wait for that. But my point with regard to the signature verification in the issue of strict scrutiny is the right to vote is, in essence, a political right. It's a right that it requires government intervention in order for you to exercise it. It's different than your right to free speech, your right to keep and bear arms, your right to conscience. Those kinds of things are your inalienable natural rights. But your right to vote, it takes government action to protect that right. If we were to allow voting just to be wide open, anybody can walk in, no registration, you can fill out as many ballots as you want, it would make your vote meaningless.
California law.
Right. So our view is that every voting restriction has to be balanced from the burden it imposes versus the benefit it provides. You can't apply strict scrutiny to every single restriction on a voting, because many of the voting restrictions are designed to protect the integrity of the ballot. So those are all cases we're fighting in the appellate courts. And I think I'm just going to stop right there, but thank you.
5 minutes for questions and
Thank you for your attention.
Hold off, wait for the mic.
Are you knowledgeable about the case of the two legislatures suing the state over convention of states?
I am familiar with that.
Are you going to be involved in that case?
Not at the initial stage, but certainly on appeal, I will be. What he's talking about, it's an important case. You know, the Convention of States issue has been around for some period of time. And there was an effort, I think it was last year in the legislature, and it has to be passed like a federal constitutional amendment. It has to be ratified by the state. Well, under the Kansas Constitution, it requires a 2/3 vote. There's an argument that's being made by the folks that support the Convention of States because it passed the legislature by a simple majority, but not a 2/3 majority that would typically be required of both houses. And they're trying to say that, well, because the federal Constitution should control how a state ratifies or calls for a convention, and since the federal Constitution doesn't require a 2/3 majority of both houses, that requirement is unlawful. So in essence, the argument is that the Kansas Constitution violates the federal Constitution. That's the essence of the argument that's being made. I actually disagree with that argument. I think the state has the right to set the boundaries and the ways we adopt federal constitutional amendments or constitutional conventions. And I think a 2/3 vote is a good policy because it means that shifting majorities can't just ram through or approve a federal constitutional amendment or a call for a convention. Whenever you need a 2/3 majority, that means you've got this enduring, strong majority to support that change, such a major change as calling for a constitutional convention or ratifying a constitutional amendment. So that's what that fight is all about, and we'll see what happens.
Okay, last question. Doctor, go ahead.
Yes, sir.
One question about Medicaid expansion,
Yes?
The Governor Kennedy wants to expand the Medicaid, but some legislators, they are not in favor of expanding the Medicaid.
Well,
Medicaid expansion.
what about it?
Is it okay with you to expand the Medicaid?
Do I what?
Is it okay with you? Are you in favor of expanding the Medicaid?
Well, that's more of a policy question for the legislature. I don't know. I don't know what General Kobach's position. My guess is he probably doesn't support Medicaid expansion. I do know we have supported some amicus briefs, bipartisan amicus briefs to oppose Medicaid fraud and make it, there have been some cases out there that would have made it harder to prove Medicaid fraud and some shifting legal standards, and we've opposed those on a bipartisan basis. I think that's been good, but as to the political issue of whether Medicaid should be expanded or not, I don't know what the Attorney General's position. My guess is he probably doesn't support it, but we don't have an official position on that.
Tony, did the Supreme Court ever let go of the Gannon case, the school finance case?
No, not yet. That was one of the things I was going to talk about when I ran out of time, but we filed a motion in the Supreme
That's for a decade, longer, right?
Right. The Supreme Court, by its own order, said that its jurisdiction should end on July 1. We filed a motion in October asking the court to issue the mandate. And what that means is when they issue the mandate, that's saying we're done with this case, go proceed, we're done. And we haven't gotten a ruling from the Supreme Court on that yet.
Anthony Powell, thank you.
All right, thank you.
That was excellent. Thank you so much.